You're looking here at a window into my life here. This is my Facebook page. If you think Facebook is totally private, even when you have hermetically sealed kind of controls, I think we're going to be sadly disappointed. Right now, this is pretty innocuous. It's a great way to see pictures of people in my office, my grandchildren, events, etc. But let's change the field and turn me into a plaintiff. This seminar is about investigation to trial. And when we meet with clients, after, hello, how are you, do you want a cup of coffee, I give my little spiel about social media and the problems that can be associated with that. I don't tell people to show me their Facebook. I don't want to see it. I don't want to know about it. I want my clients to know that any postings that they make on social media could eventually be part of a discovery battle in their case. I don't want to know what my clients have. I want them to understand that privacy may not be guaranteed. You'll have a case, and your clients testified and talked about how the accident has affected his or her life, and what usually will follow after that is a request for production and an authorization for release of your client's Facebook information. Now, you don't know what's there. You say to yourself, oh, that's, the client says to you, it's private. I have a private setting. And you argue privacy. And what do you think the defense lawyer is going to say? Well, what about the medical records? What's more private than medical records? That's authorized. That's required to be turned over. And what do the defendants want generally from Facebook? They want unrestricted access. They want everything. You are going to object and say it's overbroad, it's beyond the scope of permissible discovery, it's a fishing expedition, etc. But the defense argument is going to be that we're entitled to know if the plaintiff has made contradictory statements in their Facebook. So for example, the plaintiff who says, I can't play basketball anymore, I can't be with my kids, I can't go roller skating. They want to find, obviously, the picture of taking the kids or grandkids to roller skating. Most importantly, you're going to say, this plaintiff had privacy settings on their Facebook and therefore they should not be disclosed, meaning the plaintiff did not have an expectation that their privacy or their Facebook page would be available. The best defense, the best approach, as I'm going to show you, is that they have to have a factual predicate. There has to be some indication that the plaintiff's Facebook page is at odds with their testimony. So for example, the plaintiff who says, all my recreational activities have been suspended now and forever, and there's a picture on their Facebook page that looks like an advertisement for the ESPN X Games. They're on a skating board or something like that. Then the defense has the argument, we have a factual predicate here that gives us the right to see deeper into that Facebook. Generally, what does the defense bar say? We're entitled to it. These boilerplate motions that you're going to see, and I'll give you some samples of cases that we had. As I mentioned, no appellate decision on the issue of Facebook discovery, discoverable as of right. No decision that privacy settings entitle you to preclude this production. And as a result, as you could figure out, there's no pattern. There's varied results. We have one case here where the court granted the defense motion to compel, but in a footnote said, there's no automatic Facebook discovery. There has to be a threshold that the defense must pass that the discovery of the private pages, as I mentioned to you before, are at odds with the testimony of the plaintiff. Then we have here a middle-of-the-road approach, which is probably more reasonable, where the court says, we're going to look at this information in camera, and a judge will decide whether we're going to turn over social media discovery. Now, I had the same situation, a case that I took over helping John with. The plaintiff gave a deposition and basically said the accident destroyed her life. The defendants want to see her Facebook account, and I had to argue it's private. The profile page was like a mugshot. It gave no indication that her life is any, that her Facebook account would contradict that. My motion to bar production was granted. I think more so based on the fact that there was no factual predicate. But I think really the argument was they had taken her deposition, they had all the other tools available, enough. A digital fishing expedition is just as bad as an analog fishing expedition, which the courts have always said is not going to be permitted. This was the interesting question that I had that I don't really have a resolution to. When the client said to me, I'll show you my Facebook page. And I almost said, yeah, no. If you look at the client's Facebook page with her permission, what's your obligation then when you find things there that are not good for your case? I don't know the answer to that. And I opted in this case, I don't want to see your Facebook page. To me, you asked for it to be private. It should be private for me too. Now we have the case of an interesting situation where the plaintiff is told, the court says I'm going to allow access to the account. This plaintiff deactivates and shuts down and throws out all of her Facebook information. The New Jersey court in that case argued spoliation. The defendant asked for an adverse inference to be given to the jury and asked for sanctions against the plaintiff's attorney for not properly policing his client not to destroy her Facebook information. Good news for the lawyer, the court did not grant sanctions against the attorney, but adverse inference at trial granted. I think we got to go back to the basics of discovery battles and argue that it's overbroad, it's a fishing expedition. The plaintiff had some degree of expectation that this would be private, and fight the battle on that ground. We have to protect our clients from the other side. We have to protect our clients from themselves too. You don't have to learn the technology to know the issues. Stick to the law, stick to basic discovery concepts, and do not roll over.